Recognizes Mr. Trone of Maryland for 5 minutes of questions.
Thank you, Mr. Chairman, and Attorney General Garland. It's great to be here with you today. For the last decade or so, my office has been in Bethesda, so we're neighbors, and it's awesome to have someone of your qualifications in this job. I want to start off today about pretrial and jail incarceration rates. Even short stays, pretrial detention is associated with harmful outcomes, costing people their jobs, their homes, lose custody of their kids. This practice is also leads to an increased likelihood of being convicted, receiving a harsher sentence, and future involvement in the criminal justice system. The pretrial detention rates in the federal system are at a record level, 75% of individuals detained pre-trial. Disproportionately, this falls on people of color. Federal prosecutors have requested from 56% in 1997, now up to 77%, even though the data shows 99% of those released return to jail, to court. So, Mr. Garland, could you speak to DOJ's current pretrial retention policies and your views on pretrial detention?
Congressman, I quite agree with the concerns you express. I do think that unnecessary pretrial detention does make it harder for somebody to build a case to defend themselves, which is point one. And point two often means they lose their job, which even if they are then adjudicated as not guilty, damages their ability to make a livelihood. So there's no question about that. I served when I was the chief judge of the U.S. Court of Appeals for the D.C. Circuit on the executive committee of the Pretrial Services Agency for the District of Columbia. That's a statutory appointment. That agency has a nation-leading reputation for analyzing pretrial detainees and making recommendations to judges about which ones need to be detained, which ones don't, and what kind of more minimal conditions can be required. So, because they have a very good method of figuring out who might recidivate while on release or after release. And I know that the judges of both the federal court and the Superior Court are happy with the results of that. So one thing might be to help model that program in other districts. The federal law permits pretrial detention only if there's no combination of other kinds of conditions that will ensure the return of the person who's been arrested and secure the safety of the community. That's the underlying test. There are provisions that provide a presumption of detention when the sentence faced is extremely high or when the crime itself is extremely dangerous. But even in those circumstances, it's only a presumption.
According to the Vera Center for Justice, after the enactment of the core crime bill, we spent $127 million a year on pretrial detention, today's dollars. Today, that's over $2 billion. Yet our prison population has been reduced significantly from where it was 3 decades ago. Does this seem like somewhat of an outsized increase to you, given these crime rates are lower?
I honestly don't know. I don't know the Vera statistics. I don't whether the reference is to federal pretrial detention or not. As you can imagine, we are not charging people with low-level crimes in order to prioritize our resources and, frankly, to be fair and just. We are looking for only in the area of street crime, violent offenders, big-time offenders. So it may be that our detention statistics are higher than you might guess. For example, if what we're looking at is what a local prosecutor brings in. But to be honest, I simply don't know the statistics that you're citing.
Thank you. That's the federal number. Quickly, the president's skinny budget outlined $1.5 billion, an increase over $500 million for grants to support the reform of state and local criminal justice systems, including federal funding to support diversions and alternative court programs.
Right.
Can you expand on how the funding could be allocated to safely reduce rates of pretrial detention?
Well, that's part of the important role that these alternative programs provide. The drug courts, the mental health courts often allow people released on personal recognizance, released altogether, pending various kinds of agreements to monitoring and substance abuse, taking substance abuse programs, that sort of thing. And as you said, there's a $271 million in the OJP, Office of Justice Programs proposal, which can be given for those kinds of programs.
Thank you. I yield back.
Thank you, Mr. Trone. General Garland and members of our subcommittee, we will now take a 10-minute recess.